Okay, next we're gonna do Big Little Lies. I love this show. I watched it.
I have not seen it.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated.
Okay, you're up.
I love Nicole Kidman in this show.
Mary Louise.
Celeste?
Your attorney made me out to be quite the bad mother.
He was just asking questions. You answered them.
Is it your observation that I am a bad mother?
As you heard me tell Judge Cipriani when we were in chambers, I consider you to be a wonderfully committed parent.
That's not the impression.
As to my observations, yes. I have observed you being violent with the boys. I witnessed you throwing Max to the ground and shaking him. I saw you drive off wearing nothing but your jammies under the influence of who knows what. You say Ambien. And you crashed the car, in fact. So, you're not okay. That's my observation, which we can all accept. After all you have been through. But I cannot accept these children being placed in such imminent peril.
Did you ever report to Child Services that you believe my children to be in danger?
I'm going to stop right there because her answer was really long and it wasn't helping the mother who was asking the questions. She just asked, do you think I'm a bad mother? And the witness could have answered yes or no, but instead she continued talking and a lot more evidence against the mother came in. If mother had an attorney, the attorney would move to strike the remainder of her questions as the remainder of her answer as being non-responsive, because the call of the question was, do you think I'm a bad mother? And she went on and on describing different facts without going to details of when certain things happened, who observed them when, and the timeline. So being self-represented here is not helpful.
I probably should have.
So the answer is no.
Yeah, it's no.
Did you ever report to any other agency that you believed my boys to be in imminent peril?
No.
You suggested that I got violent with my sons. Is it your testimony that I am routinely violent with them?
No, not routinely.
Is it your testimony that I am often violent with them?
No, but who knows what I haven't seen.
So now you're basing your opinions on what you haven't seen?
I'm not a trained lawyer, so the semantics...
Please, would you direct your responses to me? I'm asking the questions.
She's doing a good job. She's asking short questions and making her point.
No, the truth of it is, you saw me lose my temper with my son once. Where I overreacted, I pushed him to the ground once.
Oh, it takes us once.
Well, you would know that better than anyone, wouldn't you, as a young mother? Did you ever lose your temper with your boys?
Well, this isn't simply about temper or temperament.
Did you ever lose your temper while you were driving an automobile and cause the car to crash? Would you like me to repeat the question?
There could have been objections to relevance because it's not about the witness and what she did.
If I remember correctly, it's coming back. The dad died, and the grandma is trying to take away custody from the mom.
Okay, then I would draw my objection.
No, I heard the question. It was obscene.
Your son Raymond died in part because you lost your temper. Isn't that true?
Objection.
This witness has testified that I put my sons in peril. It is relevant to this proceeding as to whether or not she has ever killed a child in her care.
Mrs. Wright, please sit. Please.
Grandma's about to have a heart attack.
Why are you doing this? Why are you doing
I am
this?
simply trying to protect my children. Now, the idea of you driving with my children in the backseat of your car while you lose your temper, that is terrifying to me.
Your Honor,
This is indecent.
Are you suggesting this cross-examination should be limited to decency, Mr. Farber?
Mrs. Wright, you don't get to go at him.
Indecent or not, this case is about mothering.
Oh, that's powerful.
Yeah, that was good. I think she got a lot more leeway here because she's self-represented and she's an attorney.
I think in a normal situation, if it was just the grandma testifying, on behalf of her son who wants custody, her temper would not be relevant, and that line of questioning would not be allowed. But because she's trying to get custody and she's accusing the mom of losing the temper, her temperament is directly relevant to whether or not she would be a better mom.
On the whole, it's best to have an attorney represent you because family court is extremely emotional. Judges like to get down to the facts. If you get too emotional, then you may be interrupting the court. You may be going to the subjects that the court doesn't care to hear about because you're in the mode. Something may be going through your mind and you want the judge to know this. You can lose the battle over custody over the appearances in court.
I would say, I think that in any situation, in any case, self-representation is always a bad idea. I always think about this because I think really good advocacy, really good lawyering is neutrally applying the facts to the law. And no matter how smart you are, no matter how well educated you are, no matter how well caught up on the laws you are, if you're close to something and emotional about it, whether it's a personal injury case or a family law case or an employment case, I see pro se employment litigants all the time, even people who are lawyers. But because you're so close to it, you cannot neutrally apply the facts to the law. Really, you have to be extremely able to compartmentalize, which most people cannot do. So I would say in every situation, even if you're an attorney, you should always hire representation.
It's difficult when you've been waiting for a court hearing for so long, and it's finally your chance to have your story heard and to tell on the other side so that you can convince the court to rule in your favor. If you don't have an attorney, you're likely going to want to give a lot more information that may or may not be relevant than the court has time for that day or that the court has questions about. And you can say extra things you should not, that maybe you think it's helpful to you, but it really isn't because you're processing it differently than the court has to look through the lens of the law and how to apply the facts to your case. So it could actually be damaging to you rather than helpful, and you may not know that. And speaking too much in court can be damaging. Even when you're asked questions, sometimes it's just best to say yes or no rather than to keep talking, because you may be opening the door for the other side to inquire further and give the court the snapshot of what may make you look really bad. It's kind of like making a movie. I always say that. Being in court is like making a movie, and this is your chance, 20-40 minutes to show those snapshots, kind of like a commercial, to make a convincing story. And if you spend that time on something that's not helpful to you or it goes the wrong way, well, then you didn't use your time wisely to make your case.
So here's how I prepare every single one of my clients for deposition or if they're giving testimony. Here's the secret. You have to listen to the question, then repeat it in your head. Process it before responding. And if you can answer with a yes or no, you answer with a yes or no. Don't ever offer up more information than you have to. So that's always because people want to just blurb out everything that's on their minds. And I'm always no, listen to it. Do not respond. Do not respond. Repeat it in your head. Think about what you're going to say and then respond and make it as succinct as possible.